Yes, Mr.
May it please your lordship, your ladyships, I appear in this matter with my learned friend Mr. Jason Robinson on behalf of the appellant Geoquip Marine, my learned friend Mr. Stephen Phillips, KC, and Miss Rebecca Jacobs appear on behalf of the respondents, Tower Cameroon SA and Tower Resources PLC. And I shall refer to them throughout the appeal as Geoquip and Tower, respectively, it not being necessary for the purposes of the appeal to distinguish between the defendants. May I first check that the court has all the bundles with which we think it has been supplied? There should be a core bundle.
You need to check. We've got everything. We've got the core, the supplemental. Finally, we got the contract, which is useful in a contract case, and then we got some authorities.
The court will therefore be aware that this is my client's appeal from the judgment of Mr. Peter Macdonald Eggers, QC as he then was, dated the 16th of March 2022. The issues on the appeal are quite confined. There are two questions of construction in our submission and one of causation. I do not know the extent to which you wish me to outline the underlying facts. If it would be helpful, I'm very happy to give a thumbnail sketch.
Well, nowhere is there an outline basic chronology. Oh, there's two chronologies, which are frankly sort of old hat for the purposes of this case.
Yes.
But I think we personally have got it now. I know what happened, but it's a strange case, isn't it? Because the contract is signed at the end of October. The vessel arrives. Then the contract is, the vessel goes to the work site, sent home, then the contract's extended, so that seems to acknowledge that it's all been enforced for 4 months, or going to be enforced for 4 months. And there's millions of emails we're not concerned with because you didn't get permission to appeal a stoppel. And then there's 3 days work and off we go. It's a strange little set of facts.
Well, yes, my lord. You will have seen the contract. It may be now is as good a time as any to look at the contract.
Yes.
The contract.
What a brilliant idea, Mr. Hurst.
You will find that in the contract bundle. The contract itself is at section 3, page...
But what is the status of the standard contracts? The standard contracts for UK offshore oil and gas industry, logic form?
Well, they were incorporated effectively as section 2 of the contract.
Right.
So you see, the contract itself starts at page 53 in tab 3, and if you turn the page to page 54, you'll see that it consists of 4 sections. Section 1 is a form of agreement in Appendix 1. Section 2 is the general conditions of contract. Now, those are the logic standard form conditions.
Right.
Section 3, remuneration. Section 4, scope of work. Turning the page, 2 pages in fact, you will see the form of agreement, which basically recites the parties.
So which page are you on now?
56, my lord.
In the bundle.
Electronic 57.
Oh, I'm so sorry. Electronic 57 in that case. Form of agreement recites the parties and essentially at the bottom of the page sets out the sections that are deemed to form and be read and construed as part of the contract. And you'll see section 2A, the general conditions of contract for services, section 2B, special conditions, 3, remuneration, and 4, scope of work. Then turning the page, it records that the contractor is to perform and complete the work in section 3. The terms and conditions of the contract will apply from the date specified in Appendix 1, the duration as per Appendix 1, and then the guarantee. And then we have Appendix 1, which sets out various specific provisions by reference to the particular clauses of the logic terms. And you can see that the effective date of commencement of the contract is 30th October 2019 and the duration is 2 months. And I don't think we need to look at anything else there. And then turning over to electronic page 61, you see section 2, conditions of contract, general conditions, logic edition 2, October 2003, and special conditions of contract. And the page 62 effectively records that the general conditions of contract, the logic conditions are there, although they haven't been written out in extenso in the contract. You will find them to the extent necessary in tab 1 of this bundle. And then section 2b, I'm looking now at electronic bundle page 63, is the special conditions. And these, the following pages, set out various amendments and additions to the standard terms. Now, my lord, my ladies, for ease of reference for the trial judge, we prepared, and I think this was an agreed document, a compendious document setting out the general conditions as amended by the specific amendments, showing those in track changes. And you will find that in tab 5, tab 5 of this bundle. So there you have the general logic conditions showing in red the amendments to the that have been specifically made by the parties.
And are any of those relevant to what we have to decide?
They are, my lord. Specifically, clause 4.5.
Oh, I see. 4.5 is one of those.
4.5 is one of those, and you will find that on electronic page 115, I hope. As part of clause 4, headed contractors' general obligations. I think my learned friend would want me to draw your attention to clause 4.1, which provides for the contractor, that's Geoquip, my client, to provide all management, supervision, personnel, materials and equipment, except materials and equipment specified to be provided by the company, plant consumables, facilities and all other things, whether of a temporary or permanent nature, so far as the necessity for providing the same is specified in or reasonably to be inferred from the contract. And then the clause on which we rely is 4.5, where you'll see that in order to ensure that performance and completion of the work are not delayed or impeded, the contractor shall be responsible for the timely provision of all matters referred to in clauses 4.1 and 4.4, and, where provided elsewhere in the contract, for the timely request of company-provided materials, services and facilities. And then by way of addition, an agreed amendment, there was the following provision added. However, contractor cannot be responsible for the timely delivery of company-provided materials, services and facilities. If such a delivery late and cause delay in the performance and downtime of the contractor's equipment, company shall pay stand time for such downtime. So that is the clause on which we rely. And while we're here, I would perhaps invite you to look also at clause 34 on electronic bundle page 148. Headed permissions and permits. Company, that's Tower, will be responsible for obtaining all necessary permissions to enable survey work to be carried out, including but not limited to permits from the appropriate authorities from the vessel to operate in national waters of the country or operations, and for ensuring safe access within the area of survey operations. And that, we say, is one of the clauses that gives rise to the obligation on the part of Tower to provide security for the vessel while she is in Cameroon.
It doesn't go that far, does it?
Well, for ensuring safe access, I'll come back to this point in due course, but we say that ensuring safe access in the waters off Cameroon, which is a notorious area of pirate activity, provision of security is the very essence of providing safe access. And then just going back to tab 3, electronic bundle, page 72. And this is back to the contract itself. See section 3, remuneration, as per section 10 of the attached technical and commercial proposal. And then on the next page, section 4, scope of work, as the attached technical and commercial proposal. And then if you turn the page, you find the technical and commercial proposal that Geoquip had made, which, as you can see, was incorporated into the contract. And there is one provision that you need to look at here, and that is clause 10 on electronic bundle reference, page 96. And the clause there is clause 10, headed commercial. 10.1 is pricing, and you will see that there's a table set out, and in the first half of the table there is effectively an agreed lump sum price for the services that the vessel was to provide, so mobilisation, the field work, the demobilisation and the reporting. So the basic work of the survey was to be remunerated by a lump sum. And then the second half of the table deals with rates for standby time and optional work. And in particular, you see rates at items 4.7 and 4.8 for standby at sea and standby at port. And that, we say, is the regime that covers compensation for delay. And then clause 10.2, contractual. Please refer to the logic terms. And then the third paragraph, it is understood security vessels will be provided from entry into Cameroon waters during mobilisation, throughout field works, through demobilisation and exit from Cameroon waters. And then the all-important preconditions. The offer is subject to the investigator, that's the name of the survey vessel, arriving in Cameroon between the 15th November and the 31st December 2019, and the contract is also contingent on the permits and licence extension required for the site survey having been delivered prior to the departure of the vessel to Cameroon. The offer is subject to contract signing by 15th November 2019 and advanced payment of $250,000 to arrive in Geoquip's bank account prior to departure of the vessel to Cameroon. Now, we say, and I don't believe this to be disputed, that those preconditions contained protections for both parties. And the effect of them was that Tower was not obliged to pay any deposit until the licence extension had been obtained, because they weren't obliged to pay any deposit before the vessel moved to Cameroon, and the vessel wasn't supposed to move to Cameroon until after the extension had been obtained. So the effect of that is that Tower is not obliged to pay anything until the extension's been obtained. But secondly, Geoquip was not obliged to go to Cameroon until the deposit had been paid. So both parties were protected. But of course, as matters transpired, Geoquip brought the vessel to Cameroon in early December 2019 for its own purposes and at its own risk and expense. Before the deposit was paid...
What date?
I believe it was around about the 5th of December, my lord. So they brought it to Cameroon before the deposit was paid, before any extension was granted, because they needed to carry out maintenance work after the previous employment of the vessel in any event.
He was told not to.
Well, they were told not to, and I will come back to this, but of course, at that stage, the contract hadn't come into force. And so, yes, Mr. Asher did say not to move the vessel until the extension had been obtained, but he can't dictate what Geoquip can and can't do with their own vessel. And if there's no contract...
As at the 5th of December, the contract had not come into force.
That's correct. Mark.
As at the 26th of January, it was agreed between the parties that the contract came into force on the 30th of October.
No, my lord, not quite. It was common ground at trial that the contract had come into force at the latest by the beginning of January 2020.
What does that mean?
Well, what happened, of course, was that if I can backtrack slightly, after the vessel had arrived for the maintenance work.
Sorry, at the latest on the 5th of January.
No, by January.
So by January.
By January. That, I think, was the concession made by my learned friend below.
That's recorded at somewhere about 95 in the judgment.
I believe your lordship is correct. I believe it was paragraph 96, subparagraph 8, in recollection. But
96A. Right. So how does that all work?
Well,
that's the bit I find difficult with.
Yes. On the 24th of December, Tower were told that the extension had been granted, and that is what they told my clients on the same day. And if you look at the judgment in Core Bundle tab 10, page 83, I hope that is the same pagination as the electronic bundle.
Sorry, this is Core Bundle page 83.
Yes, this is the judgment.
Oh yeah, I'll look at the judgment separately. Which paragraph is the judgment?
34 to 38.
Yeah.
So we see on 24th December, Mr. Asher sends an email to Mr. Harmon, that's one of my client's employees, stating that the licence extension letter has just been signed and attached a photo of the letter. In fact, according to the written and oral evidence of Mr. Asher, this was not the presidential decree which constituted the formal extension, but instead the minister's recommendation to the president to issue the relevant executive order. And the minister is the Minister of Mines. I think his ministry is abbreviated to MINMIDIT. Later that day, Mr. Asher informed Mr. Harmon by email that we should now send you the 250,000 deposit for the survey. So on the 24th December, the vessel proceeded to an anchorage to perform clearance. On 27th December, in an exchange of emails between Mr. Harmon and Mr. Diarou is Tower's general manager in Cameroon, and Mr. Asher, it became clear that Tower Cameroon did not yet have the licence extension, but only the minister's recommendation for the licence extension. On 27th December, Mr. Harmon wrote to Mr. Diarou setting out a timeline, culminating in the vessel sailing to the worksite on 5th January. On 29th December, Tower Cameroon paid the deposit. Now, as I will be showing you in due course, we submit that the evidence shows that even though Tower knew at the time they paid the deposit that they hadn't received the extension itself, only a recommendation, they certainly understood from that the extension would be granted, and of course they were sufficiently confident that it would be granted to pay the deposit, even though, as I've already submitted, they were not obliged to do so because they were entitled to stand on the precondition so that the contract should not come into effect.
When did the contract come into force?
Well, we say it came into force certainly no later than the 1st of January, but probably when the deposit was paid.
Well, I mean, probably is not a helpful submission. Contracts don't work like that.
No.
They either come into force or they don't come into force. They either exist or they don't exist.
Well,
now, do you say that the contract came into force when the deposit was paid, as at the 29th of December? Because if so, that is inconsistent with what was agreed in the extension, and therefore there must have been a variation.
Perhaps I have to put it this way, my lord. On the 29th, by virtue of the payment of the deposit, the parties agreed that the contract should become effective in accordance with its terms. And one of the terms of the contract was that it should be effective as of the 30th of October 2019. So what our submission is that when the deposit was paid on the 29th of December, the parties agreed to press the go button, so that the contract should come into force in accordance with its terms, one of those terms being that it was, in fact, effective as of 30th October. I think that's the way it works contractually, my lord.
Right, so your submission is the contract, as at the 29th of December, there was an agreement that the contract should take effect according to its terms.
Yes, and thereby the parties necessarily waived the precondition for the licence extension to have been obtained.
They waived.
Yes. They waived that precondition.
Has that ever been said before?
Yes, that was my submission.
And what did the judge say about the waiver submission?
I'm not sure that he did say anything specific about it, but it was common ground that the contract had come into force. There was some discussion before him as to whether this was on the basis that it was assumed that the precondition had been fulfilled, and my submission was that that was not correct, because obviously the precondition had not been fulfilled. It was simply that the parties, by agreeing that the contract should come into effect, must necessarily, by their conduct in so agreeing, have agreed to waive any precondition based on the obtaining of the licence extension.
Right.
So thereafter, the vessel then mobilised, and the parties agreed that she should depart for the drilling site to carry out the survey on the 8th of January. And it is only at that point that my clients regarded the vessel as being at Tower's risk for the purposes of the standby regime. Now, it was not in dispute.
Hang on. That was when you, Geoquip, decided that the vessel should be at the defendant's risk.
Well, not decided, but that was the date from which we considered the standby regime would start to apply. Not before, but only at that date. The mobilisation was, of course, covered as part of the lump sum remuneration. So there will be no question of the standby regime applying until after the vessel had mobilised and was ready to go. And that was an agreed date of the 8th of January. And now, of course, we've seen that it was the obligation of Tower under the contract at its own cost and expense to obtain not only the licence extension but also to provide security, and that is not in dispute. And security had been arranged and paid for by Tower and was to be provided by the BIR, which was a section of the armed forces. However, in the event, the vessel did not depart from the survey site on 8th January, or indeed for many weeks thereafter. And the reason was because the state oil company, SNH, Société Nationale d'Hydrocarbures, refused to authorise the BIR to attend without itself having seen a signed presidential decree authorising the extension.
SNH refused what?
To authorise the BIR to provide security, to attend.
Without itself seeing what?
A presidential decree authorising the licence extension.
There never was a presidential decree, was there?
It doesn't appear so. In fact, the evidence of Mr. Asher was that he still hasn't seen a piece of paper signed by the President. But in the event, the security was not authorised until early February, and the survey was eventually carried out from the 4th to the 7th of February. And meanwhile, the vessel had been sitting in port idle for around a month, apart from one abortive attempt to carry out the survey in mid-January, but it's unnecessary to go into detail about that for the purposes of this appeal.
We did go to the site on the 15th of January and then was sent back again.
And they were sent back again, yes.
Yeah, okay.
And that again was because the SNH ordered the Navy to bring her back because they were still not satisfied they'd seen a decree. So, of course, one of the very important matters which arises on this appeal is whether in these circumstances the cause of the delay was the lack of security or the absence of a signed extension letter, or whether both were operating as concurrent causes.
One is dependent on the other, surely.
No, my lord. Well, it depends which way around you look. The licence extension, we agree, and the judge found that the provision of security was a precondition to obtaining the licence extension, but we say he did not make any finding that the converse was true.
Sorry, provision of security was a precondition to extend...
To getting the extension. In other words, the extension would not be granted unless the President was satisfied there was adequate security in place.
That was common ground.
That was common ground. But we say the converse is not the case. The judge did not so hold.
Well, can we define? You say that in your skeleton, and I've put the requisite number of wet towels around my head to try and understand what the converse is that is not the case, with all those negatives. What is not the case?
The provision of security was not either legally or factually dependent on the obtaining of the licence extension. And I will come back to develop that in due course, because that goes to the causation point, which is a major part of this appeal.
But isn't that the only part of this appeal, really?
Well, my lord, I would be delighted if it were, but my learned friend takes issue with two
Well,
and
you've got
two.
the respondent's notice, but he'll open his respondent's notice.
Well, he will, but he takes issue first as to whether the clause 4.5 actually covers the provision of security at all, and secondly, whether as a matter of construction, and this I fear really is a bit of a wet towel around the head exercise, but whether clause 0.5, even if provision of security is covered by clause 0.5, whether it has to be the sole cause in order to operate, because clause 4.5 doesn't apply to delays caused by failure to get the extension. And
Yes.
we say the judge went wrong on his construction of clause 0.5.
Well, he says the judge should have found that the only operative or effective cause of any delay was the absence of a presidential decree confirming the licence extension. That's what he says.
Yes,
That's in his respondent's notice at paragraph 2b.
yes.
And that is at odds with your saying, I think, what you say, which is that the provision of security is separate from the provision of a licence extension.
Indeed it is. Indeed it is.
And you have to succeed to show us, don't you, that the provision of security was a separate operative cause of delay. And the question I ask is, isn't it obvious from the facts that the BIR was never going to allow you to undertake this survey until there was a presidential decree, because that was why I call them NHS, but it's SNH, I think. Perhaps NHS would be easier to remember. That was why SNH sent you back.
Yes. Well, my lord, I was going to come to causation as the third of the issues to be addressed by the court, but I'm very happy to deal with it now, as you've raised the point.
Okay. I mean, if you could just give me a simple answer to the simple question, then you can go back to the questions of construction.
Well, we say we say that in fact that is not a sustainable proposition on the evidence.
You say it's, just say it slowly, you say it's not clear on the evidence.
We say it is clear on the evidence that the factual cause of the delay was the lack of security and not the absence of the licence extension. And I will show you the evidence that we say makes that good as a matter of fact. And we say further that legally the reason the SNH were giving for not authorising security was likewise irrelevant. Now, I've already submitted that the judge did not hold that the provision of security was either expressly or legally dependent on the obtaining of a licence extension. And we say that's an unsustainable proposition as a matter of generality in any event. Because if you say that the provision of security is dependent on the obtaining of a licence extension, that means that only vessels who have drilling licences can get security in Cameroon, and that's plainly nonsensical. And
no, but isn't, I mean, that obviously is nonsensical, but that's not the logic. I mean, the logic,
no, I follow that. I'm taking it step by step. I'm building my argument, my lord. And also, the court should note that the BIR did attend the vessel when she first arrived in Cameroon. They didn't escort her into territorial waters, but they certainly attended her thereafter. And that, of course, was before any licence extension had been obtained, before any deposit had been paid. So security clearly could be provided in principle. And you can see that from paragraphs 31 and 32 of the judgment. Where the judge sets out some of the correspondence from Mr. Asher. And perhaps I could just invite you to look at those. It's tab 10 of the core bundle, pages 82 to 83. Paragraph 31, this is, the judge records the minutes of a board meeting of Tower on the 9th of December. And this is after the vessel had arrived in Cameroon. And my lord, I have to correct myself. I think I said that she arrived on the 5th. She actually arrived on the 2nd of December. That's judgment paragraph 29. But anyway, in the board minutes, it's recorded that the minister has told us he's approved a licence extension and written a letter, but has not sent it because he wished to inform the SNH as a courtesy before doing so. The licence extension has also been strongly supported by the Prime Minister. In the meantime, Geoquip's MV investigator is now in Douala and secured by the BIR. And then the following paragraph, Mr. Asher is writing to the Prime Minister, further to a meeting that had been held on the 15th of November, and he, over the page, the second complete paragraph on that page, we've been granted a normal temporary admission by the Customs Office to clear the vessel, and the BIR has secured the vessel and the crew to avoid any security incident while in Cameroon water territory. So clearly the BIR were able to provide security irrespective of any extension.
Well, obviously they could. But the question is not whether they could provide security for the vessel against people running on shore and, just damaging it. But the question is whether they could provide security for the purpose of the performance of the contract.
Perhaps I can show, yes, well, I mean, that's my learned friend's case. Is he said, well, look at the situation on the ground. He says the factual cause was the lack of licence, not the lack of security. And of course, I accept that was the reason that was being put forward why the SNH refused to authorise the BIR to attend. But we do say that ultimately this is a bad point which goes nowhere. And I would like to develop this by reference to some of the evidence, because all the indications were that the licence extension had been authorised by those whose job it was to authorise it. That's the Minister, the Prime Minister and the President. And of course, even Tower was sufficiently confident from as early as the 24th of December that it would be granted to cause Tower to pay the deposit when it wouldn't otherwise have had to do so. Now, the starting point is paragraph 34 of the judgment. This is the page that we were just looking at, the third complete paragraph of Mr. Asher's email. Your Excellency, Tower has kept its word and has accelerated the arrival of the vessel into Cameroon as soon as we left your office, and that would have been the meeting on the 15th of November. The vessel has been performing maintenance activity in Douala while waiting for the extension letter to be delivered so that it can commence work. But this maintenance work has been completed some days ago. We're now facing the risk of the vessel leaving Cameroon to undertake other work elsewhere if the promised extension... Oh, I'm so sorry, my lord, that's a completely wrong reference.
I mean, what I don't understand is how on this appeal, which is billed as appeal on a point of law, we can get into re-hearing the facts. I mean, the only fact on which you've appealed, I mean, let's look at your grounds of appeal. Time to find them.
It's tab 1 of the core bundle, pages 12 to 13.
So the judge erred in law in holding the claimant had no contractual right to standby charges under clauses 4.5 and 34. And that was the one you got permission on. Did you get permission on 2?
We got permission at page 177. Of the bundle.
Only ground 1.
Ground 2 was your estoppel.
Sorry.
Ground 2 was estoppel. Ground 1, sufficiently arguable failure to provide security team was breach of the obligation to provide a facility within the meaning of clause 4.5. It is also arguable that the failure to provide a security team was an operative cause of standby charges being incurred, notwithstanding that the provision of security was conditional upon the obtaining of a licence extension. So we did get permission to appeal on causation. And in my submission, I am entitled to address your lordship and your ladyships on this matter. Yeah. And we would say in any event it was covered by ground paragraph 2.2 of our ground 1, where we said the learned judge in any event erred in failing to hold that clause 4.5 entitled the claimant to claim standby, where the failure of the first defendant to provide security was an independent concurrent cause of the delay. So the question of causation, we say, is fairly covered by our grounds of appeal and also by the permission that was granted by Lord Justice Phillips. So, my lord, perhaps I can just show you some of the evidence to make good our submission that, in fact, the sole cause of the delay, in fact, was the lack of security rather than the lack of the licence extension. And for this, we need to turn to the supplemental bundle. And tab 1 is the transcript from the second day of proceedings. If I can ask you to turn to page 9 of the bundle. Page 30 of the transcript starting at line 13. And this is a quotation from an email sent by Mr. Asher, not to Geoquip, but to another consultant. And he says, "Dear all, as most of you know, the Minister approved our licence extension on Tuesday." I'm sorry, this is on the 29th of December. I attach a copy of the letter taken on Honoré's phone, that's Mr. Diary. Technically, the extension itself is a presidential decree signed by the President, so we don't know when we will have that in hand. However, the Minister's letter was signed on Tuesday specifically to allow the authority to be given to Geoquip to perform the site survey work for us on the licence, and that authority is being processed already, so in substance we are there. And then if you turn to the next tab at page 73 of the bundle, and this is part of Mr. Asher's cross-examination, page 118 of the transcript, and I put to him an email that he had written, starting at line 12, I think. I think you say in the last paragraph of this email you met the Prime Minister, who confirmed our extension would be granted, and we're currently working on extracting a visible letter to that effect. So that's putting a quotation from one of Mr. Asher's emails. Answer, yes. And is it right that you were confident that would happen? You know, in most countries, when the Prime Minister says something will happen, it does happen, and indeed it did. And then moving on to pages in the transcript, so still on the same page of the bundle, page 120 of the transcript.
So sorry, I don't completely understand what all this is about. You are trying to show, are you, that the extension was in the bag in December, and that the delay was caused by BIR not providing security.
Yes.
And there was never any doubt from December that the extension would be provided.
Precisely so, my lord. And we say the unwarranted intervention of the SNH, who are a non-contractual party, they have no legal standing in this contract whatsoever. We say the unwarranted interference of SNH sticking their oar in and deciding for themselves that they need to see a decree cannot legally or factually alter the position, which was that the licence extension wasn't a problem, because it's clear from this evidence and more evidence that I can show you that there would have been no objection to Geoquip carrying out the survey on the part of the President or the Minister or the Prime Minister, even if the formal decree hadn't been issued. In fact, the purpose of the Minister's letter on the 24th of December was precisely to allow the work to go ahead. That was not the problem. It was because the officious SNH, for reasons best known only to themselves, decided to stick their oar in and say, well, we want to see a decree for ourselves before we authorise the security. And we say that cannot, either legally or factually, be relevant. It's legally irrelevant because SNH, as I said, had no contractual standing, no legal status as far as this contract was concerned. They are not mentioned anywhere. There is nothing in the contract which says they have to be satisfied about anything. Their views and actions have no legal relevance as between Geoquip and Tower. The contractual precondition in clause 10.2 refers to the delivery of the licence extension, but whatever that means, it certainly doesn't require delivery to SNH. So we say their interference was just unjustified.
And by extension, the reason they gave for interfering was irrelevant too.
Precisely. But we say it's also factually irrelevant because, as you can see from Mr. Asher's own witness statement, which is in tab 5 of the supplemental bundle at page 169. He says, technically, the vessel could not begin work on the survey until the ATN was processed. That was one of the clearance documents allowing the vessel to enter Cameroon, which takes a number of days. He and Navitrans have been discussing getting permission from customs to begin work before the ATN was officially operational. We were adopting a similar approach with the licence, and the Ministry of Mines had told us informally that they had no objection to our beginning work immediately while waiting for the formal decree. On 4th January 2020, we contacted the BIR about our wish to begin work on the survey as soon as possible, agreed a meeting at 11 a.m. on the 6th to discuss security arrangements. At that time, we were planning for the mobilisation of the vessel to the survey area on the evening of 8th January, even though we did not have the licence extension in hand, and I wasn't aware of the status of the ATN. However, my belief was that the decree in the ATN would either be issued by the evening of 8th January, or else that the government of Cameroon would allow the survey to go ahead, even if the paperwork was not yet in hand, since this appeared to be their wish and intention. Neither I nor anyone else at Tower had received any indication to the contrary. So Mr. Asher's own evidence was that so far as the government was concerned, there was no impediment to Geoquip carrying out the survey, even though the formal extension had not been granted.
So you say the judge was right to say that there were discrete causes, and that takes you into your causation point.
Well, we would actually go further. We would actually say that on the facts, when you looked at all the evidence, the sole cause was the lack of security, but at the very least, there were two operative concurrent reasons.
What were they?
Well, one was, if you're against me that the interference of the SNH was irrelevant, if you find that factually the reason for the SNH refusing to authorise the BIR to attend was the lack of the licence extension, and if you find that that was a factually and legally relevant matter, then we say that was one reason. But on any event, it was the lack of security. We say that they were both equally, concurrently operating causes. And it is absolutely clear, as I submitted in closing, and you don't need to look it up, but the reference is Supplemental Bundle, tab 3, page 107, day 4, page 67 of the transcript. If the SNH had been overcome by an excess of goodwill and decided to authorise the security, there is absolutely no doubt that this survey could have been carried out, irrespective of the lack of an extension. And perhaps I can show you another...
Did the judge agree with you about that?
I'm sorry, my lord?
Did the judge agree with you about that?
He didn't address it in his judgment, my lord. So we say it wasn't the lack of a formal decree authorising the extension which was the factual cause of the delay, but rather the unjustified interference of a third party with no contractual standing whatsoever.
So SNH is what? The
It's the state-owned oil company.
state-owned oil company. What's it got to do then with the survey?
I have no idea, my lord, but apparently it had some sort of sway over authorising whether the BIR could attend or not. There was no evidence as to how or why the SNH came to have such de facto control. But if I may, my lord, I would like to show you just 4 more passages in the evidence, all in the supplemental bundle at tab 2. And the first is at page 73 of the electronic bundle.
I'm sorry to, I was just going back to the statement of Mr. Asher that you took
Yes.
us to previously. And you took us to paragraph 13.1.
Yes.
And in the next paragraph, he tries to explain, picking up Marshall Rose's point about why SNH would have any sway anyway. But I read on down the page, and in paragraph 33, Mr. Asher, contrary to the other bits, but to what he seemed to be saying in oral evidence on your case,
Yes.
says in writing in his statement that he believed the fundamental issue at the time was the absence of the degree, and he was frustrated at the approach of SNH and the BIR in insisting on seeing the document in contrast to the more laissez-faire approach of the ministry.
Well, he seems to blow a bit hot and cold on this, because it certainly wasn't what he was saying necessarily in his oral evidence. But in any event, my lady, the two are not mutually exclusive. Certainly,
I'm sorry, he does finish that paragraph by saying, I also understood that the decree itself was the operative document. And this is why I'd originally made our contract subject to the document.
yes, my lady, we would say that's a slightly self-serving statement, because it's quite clear, if you look back to paragraph 31, that he was clear that the relevant authorities were quite content for the survey to go ahead, notwithstanding the lack of a decree. And that's why I want to show you these further passages in his cross-examination.
Yes.
So back to page 73 in this bundle, electronic bundle. Page 120 of the transcript, picking it up at line 19, he says, well, really, it's the ministry. The MINMID is there referred to. The PM's office were involved in this as well and were chivying everyone along. But ultimately, the people who had to do something at this moment, it was the Ministry of Mines, and it wasn't SNH either. SNH are the technical advisor to the minister, and they were rather holding things up by just constantly raising objections and asking questions, which is what SNH does. But it's the minister who had to make the decision and recommend to the president to do the extension. So Mr. Asher is there downplaying the role of SNH and confirming that the really significant people in this whole affair
So
are
which
the
page
minister.
are you on? Which page?
I'm so sorry, my lord. Page 73 of the electronic bundle.
Yeah, thank you. Yeah.
So the movers and shakers, the minister and the prime minister, not SNH, and that's what Mr. Asher was saying. That it's the minister who makes the decision and makes a recommendation to the president, and of course that's exactly what happened on the 24th of December. And then if you turn on a few pages to page 78 of the electronic bundle, and at page 139 of the transcript, at the top of it, I put to Mr. Asher his email where he says, the license extension letter has just been signed and Honoré has sent me a photo which I attach for your files. I'm sure he'll be coming back to you. Thanks for your patience. And I put to him, you tell Geoquip here that the license extension letter has been signed. You attach a copy. And you are in this email giving Geoquip the clear impression that the extension has been granted onto you. Answer, well, the letter speaks for itself. The letter from the minister, and my understanding of that letter, was that it meant that, first of all, he was making the formal recommendation to the president to provide the presidential order. And secondly, my understanding was this was actually in response to pressure from the Secretary General of the President's office to say we must get this file closed now and we must get this sorted out, so will you please send this letter. So my understanding was that this letter was the beginning of the process by which all the relevant paperwork would be done, and also the reason why the minister was copying us, so that we'd know it and could alert other people and start to get ready. So it was the key letter, but it was what it was. I wasn't trying to pretend that it was anything other than what it was. And then if you, line 6 of page 140 of the transcript, I put to him, "You knew when you sent the email that it wasn't the extension itself?" And the answer was, it wasn't the presidential decree, but to say the extension letters is a colloquial phrase. It was the letter that manifested the minister's recommendation to the president to go ahead and issue the executive order. So that's what it was. It's part of the extension process, and it was a very important letter. And then turning over the page in the
What is the date of the very important letter? Sorry.
24th December. This is the one
Yep.
that my clients were told was the extension. Was the recommendation from the Minister of Mines to the President to issue the extension. And then over the page 141 of the transcript.
But so we're going to looking at all this, but did the judge make any finding to the effect that you're relying on, that the SNH intervention was an unwarranted intervention which had no legal or factual status affecting the legal position, and that there was no objection to Geoquip doing the survey before the decree was issued, and so on?
No, he didn't, my lord. The only passage in which he deals with causation is paragraph 109 of the judgment.
So don't you have to keep yourself within 109?
Well, what he says is a review of the events summarised. This is on page 97 of the core bundle. Halfway down the paragraph, he says, however, a review of the events summarised above makes it clear that the absence of a presidential decree confirming the licence extension, the absence of the permits of the vessel, and the absence of security of the vessel were all equal causes of the delay suffered by the vessel. And then he says, in the circumstances, there's no provision of the contract entitling Geoquip to stand by. And that, he says, on the basis of what we say was his erroneous approach to construction of clause 4.5, which we say he in substance construed as an exclusion clause without warrant. But he took the view, and you can see that from the start of paragraph 109, that the only way Geoquip could recover standby was if the failure to provide security was the sole cause of the delay. And we say that is wrong. As a matter of construction and analysis and reasoning, that is wrong. But that's a separate issue. But so far as actual causation is concerned, he says that there were equal causes of delay: the absence of the decree, the absence of permits. I'm not entirely sure what permits he was referring to, and the failure to provide security. And we say, even on that basis, that's good enough for us. Because
it's not good enough, which is why this is interconnected with the respondent's notice. It's not good enough if it is right to say that although non-provision of security was a cause of delay, non-provision of security was entirely dependent on the absence of the permit or the extension.
Well, it's only wrong. That's only the case, my lord, if clause 4.5 effectively excludes any claim for standby where caused by the failure to obtain the extension. And that is the second main attack we make on the judgment, which the judge seems to have turned clause 0.5 into an exclusion clause sub silentio.
Well, because he said that the whole contract was conditional on the extension.
Yes, and we say there was a failure of analysis. there, which was undoubtedly my fault, because if there was a failure analysis, it's because counsel didn't present the case correctly in the first place. But I do have the opportunity now, before this court, to try to submit what the correct analysis should have been. We say his whole approach to clause 4.5 was flawed. And if I'm right about that, then his finding that the failure to provide security was an equal cause is sufficient for my purposes.
You see, he was construing the clause 4.5, as it would have been construed as at the 30th of October, wasn't
Yes.
he?
That's absolutely right and orthodox.
Well, it is right and orthodox, but then why isn't it also right and orthodox to say that as at the 30th of October, the whole contract was conditional on the licence being granted, and so it can't have been thought that clause 4.5 was dealing with standby charges caused in any way by the contract
Yes.
not having come into effect due to a lack of an extension.
My Lord, may I just wrap up my submissions on causation, and then we can turn to that question of construction, because that is, in our submission, quite a complicated
Right.
one. But if I can just wrap up on construction.
That was why you all happened on a half-day estimate for this case, was it? Because it was so simple.
Julia, just an answer to the question that
Forgive
Master
me.
de Rol posed you. I think you need to take into paragraph 34 of the judgment, where the judge does deal with Mr. Ash's evidence.
Thank you. 34 of the judgment.
Yes, that's where he deals with Mr. Ash's evidence.
Yes. My learned friend helpfully reminds me that the judge did address Mr. Ash's evidence in paragraph 34 of the judgment, where he said that, referring to the letter, the minister's recommendation letter on the 24th, the judge says, in fact, according to the written and oral evidence of Mr. Asher, this was not the presidential decree which constituted the formal extension, but instead the minister's recommendation to issue the relevant executive order. Well, yes, that's not in dispute, and that was known at the very latest by the 27th of December that it was only a recommendation and not the extension.
Your criticism is there should have been an extra sentence in there which said, notwithstanding that being the case, it was clear also from Mr. Ash's evidence that they were content for the work to proceed.
Yes, indeed, my lady. Forgive me 1 minute. I'm so sorry. I managed to break my glasses, and I'm working off the peg pair of reading glasses which don't quite cut the mustard with A5 transcript on them. Yes, page 79. Of the supplemental bundle. Page 141 of the transcript, page 9. Picking it up at line 10. This is Mr. Asher's in cross-examination. I was confident, based on this letter, and this is the 24th December letter, the recommendation letter. I was confident, based on this letter, and knowing that the circumstances and the rest of the process, that the presidential order would be coming through very shortly. And since this was one of the preconditions and we were in the middle really of a holiday period, I felt I didn't want any delay in the communication of the $250,000 through the banking system to be the last thing that stopped the vessel being ready to start mobilising and so forth. And then if we go down to the next page of the transcript, so page 142 of the transcript, I put to Mr. Asher that it was a clear indication that Mr. Harmon, at least, that's Geoquip, thought the extension had been granted. Well, I don't know what he thought, but he was certainly correct that it was very good news regarding the licence extension, and that the licence extension, if his understanding was that the licence extension was now on its way, he was absolutely right. That was my understanding too, and it was correct. And then the last And then there are further passages to the same effect. I won't read them out now, but perhaps I could ask you to take note that the whole of that passage of Mr. Asher's cross-examination up to page 146 of the transcript, line 16. And perhaps I will just show you on page 146, this is page 80 of the bundle, at line 7. Technically, this is Mr. Asher again, technically the extension itself is a presidential decree signed by the President, so we don't know when we'll have that in hand. However, the Minister's letter was signed on Tuesday specifically to allow the authority to be given to Geoquip to perform the site survey for and from the licence that authority is being processed. So in substance, we are there. That is that is a quotation from a letter written by Mr. Asher at the time. And then the final passage in the evidence that I wanted to show you on this was over the page on page 81 of the electronic bundle, picking it up at line 19 of page 151 of the transcript. I want to ask you some questions about standby. I think it's fair to say you were very frustrated by the delay in getting the presidential decree, the licence extension. Is that right? Well, it wasn't the presidential decree that I was frustrated about. It was the BIR. The BIR should just have come aboard and provided the security. What was happening, and this only became apparent over the coming days, was that SNH had given them an instruction not to provide security until, essentially further notice from SNH. And SNH were taking the position that they weren't satisfied that the presidential decree had been granted, even though my understanding is, in fact, the President's order had already been communicated at least to the Prime Minister's office and the Minister. And from that point on, the issue became, it wasn't just, the presidential decree, if we'd had as I said, embossed letter signed by Paul Biya, that would have put matters to an end. But in fact, what was in practice important was that either such a letter was stuck under their nose, or they had a direct communication from the President himself, or I thought from the Secretary General of the President's office, to assure them the President's order had indeed been made. So from the vessel's point of view, and from your point of view, I put to him, the practical obstacle was the BIR. Initially, I thought that might be a way round the problem. Sorry to interrupt. But behind the practical problem with the BIR obviously was another problem. I don't want to oversimplify it, but the BIR was the immediate problem. So we say the evidence is really all one way, that it was the lack of attendance by the BIR that was the immediate problem. And indeed, Mr. Asher accepted contemporaneously that the attendance of the BIR was the only thing preventing the vessel's departure to the survey site. And if I can invite you to look at paragraph 52 of the judgment, this is in the core bundle, page 86.
Sorry, what paragraph?
52, my dear. And this records an email sent by Mr. Harman of Geoquip to Mr. Asher, attaching a daily project report to keep you well informed with charges being incurred by Tower Resources whilst the investigator remains awaiting BIR attendance, which is currently the only item preventing her departure to the project site. In reply, Mr. Asher said, "I am acutely aware." And both in his cross-examination and he made clear that what he was agreeing was that the BIR attendance was currently the only item preventing the vessel's departure. And the references to that are supplemental bundle, page 84,
This is not the way you put it to the judge, is it?
No, it isn't, because I was putting to Mr. Asher that what he was acutely aware of was the fact that standby charges were accruing, that he was effectively accepting everything that was said in Mr. Harmon's email, including the fact that standby charges were accruing for Tower's account. And the judge didn't accept that. He didn't accept that Mr. Asher had ever said anything overtly to suggest an acceptance of standby charges, but that was all relevant to the estoppel case. But certainly Mr. Asher was at pains to explain in his cross-examination that all he was accepting was the bit about the BIR being the sole item preventing the departure of the vessel. And I don't want to take up too much time, but if I just give you the references, it's supplemental bundle page 84, page 161, 162 of the transcript, 161 and 162, 161 at line 15. Yes, I wrote back immediately saying, yes, I'm acutely aware of the BIR problem being what we're waiting for. And then something similar at the bottom of page 162 of the transcript. And for what it's worth, that picks up what Mr. Asher said in his written statement at paragraph 43, page 174 of the supplemental bundle. I replied, I'm acutely aware, referring to the remark that the non-attendance of the BIR was the problem preventing the vessel's departure. So we say, just wrapping up on causation, we say that on the basis of the evidence, the true reason, both factually and legally, for the delay was the failure to provide security as a result of the SNH's unjustified interference, not the lack of a licence extension, which would not in itself have been a problem because it had been formally approved, even if not embodied in a decree. It would not have been a problem, but for the interference of the SNH. And in those circumstances, we say that it was the lack of security that was the cause of the delay, but at the very least, lack of security and the lack of extension were equal causes, as the judge found in paragraph 109. And we say they were concurrent causes, and that on orthodox principles, that is sufficient to enable Geoquip to provide to recover standby, unless one of those causes happens to be positively excluded. And the authority we cite in support of that proposition is FCA against Arch, which is in tab 3 of the authorities bundle, paragraphs 171 to 176. And unless you wish me to, I don't propose to turn it up, because that is trite law. So perhaps I could now turn to the point that the Master of the Rolls raised on the application of clause 4.5 to delays in circumstances where it was a precondition of the contract that the licence extension be obtained before it comes into force. Now, it is not in dispute that in construing a contract, one is looking for the objective intention of the parties at the date of the contract. It is also not in dispute that the construction which applies then does not thereafter change. However, what we do say is that one does need to take a bit of care in framing the question which the hypothetical objective parties are supposed to be considering at the date of the contract, because there is always a real danger of reverse engineering the question of construction by allowing the precise post-contractual events which occurred to inform the question of whether the parties objectively intended for a particular clause to apply or not into those circumstances. Now, we do say that's a trap into which the judge may inadvertently have fallen, and perhaps I could now take you back to paragraphs 106 and 109 of the judgment at page 97 of the core bundle. He sets out the contingency. He said that meant that there was no contract and therefore no contractual duties in place, and unless and until such license extension and permits were obtained, it would follow that any delay suffered by the vessel after the contract entered into force by reason of the unavailability of the relevant license extension and permits would not have been within the parties' contemplation as falling within the scope of 4.5, because the contract contemplated that it came into force only after the license extension and permits were obtained. It is therefore unlikely that the parties objectively intended clause 4.5 to apply to any delay in obtaining the relevant permits or extension. This consideration also applies to the other provisions referred to above. And then going to 109, this last consideration, in other words, that this remains the construction of the contract, might not have been relevant had the cause of the delay been solely the refusal of the BIR to provide security for the vessel. Now, was that reasoning correct? With the greatest of respect, we say no. We agree with the learned judge so far as to say that clause 4.5 would not ordinarily apply to delays in getting a license extension. But we say his reasoning, as disclosed in paragraphs 106 and 109, discloses two major flaws. The first is a failure to analyse correctly the question which the parties needed to address with their hypothetical objective intention in October 19, with the result that his reasoning proceeds on the basis of a fallacy. And the second major flaw, we say...
Sorry, just take that a bit slowly, will you? With the result that the reasoning proceeds on a fallacy.
On a fallacy.
Yeah.
And the second major flaw, we say, is that the judge has indulged in judicial sleight of hand.
Gosh.
Even if he was right to say that the parties didn't objectively intend clause 4.5 to apply to delays in obtaining a license extension, we say he was wrong, but even if he was right, that is not the same thing as saying that they positively intended it not to apply to such delays. And yet that is exactly what he seems to have done in paragraph 109 by saying that delay caused by lack of security would have had to be the sole cause of the delay in order for clause 4.5 to bite. So what he's effectively done is to turn clause 0.5 into an exceptions clause by saying that it cannot in any circumstances apply to delay in obtaining the extension, even if this was only a minor part of the factual clause. We say that was unwarranted. So perhaps I can unpick those two flaws. My Lord, my Ladies, I should have said that I did prepare a speaking note, effectively mirroring my submissions, but as we've gone round highways and byways and taken them back to front, I'm not sure that it would be of assistance, but if it would, I'm perfectly happy to hand it up, if it helps.
Well, you can hand it up if you want, electronically in my case, otherwise I won't be looking at it.
Right, well I can ensure that gets done, my Lord. If you would like it now, it can be handed up. But anyway, starting with the failure of analysis, what we say has gone wrong here is that the judgment fails to distinguish at all between three possible scenarios when looking at the objective intention of the parties back in October 2019 when this contract was agreed. The first scenario is entirely straightforward. The extension is granted, the contract becomes effective.
Contract is...
The extension is granted, and the contract becomes effective. Obviously, there can't be any delay in obtaining the extension because on this hypothesis it's already been obtained. Equally obviously, clause 4.5 won't apply. But that is nothing to do with the intention or contemplation of the parties. It simply reflects the fact that on this hypothesis, there won't ever be a factual situation where delay is caused in getting the extension. There is therefore no need for the parties to have any contemplation or intention about the application of clause 4.5 to a delay in getting the extension. It's simply not a meaningful question. Clause 4.5 can just be applied in accordance with its terms. So that's one possible scenario that they would have contemplated in October 19. Second scenario is equally simple. Suppose the extension had not been granted, parties had not agreed to waive the precondition, the contract would never have come into force at all. Again, the question of whether clause 0.5 was intended to apply to a failure to obtain the extension would be meaningless, because there would be no contract at all. No clause 4.5, no performance, no delays. But once again, this is nothing whatsoever to do with the contemplation or intention of the parties, simply a function of the fact that where a contract doesn't exist, it can't apply to anything. And no one will be performing it, so you could never have a factual situation to which it might otherwise have applied. Which brings me on to scenario 3, which is our case, because the question as to the scope of clause 4.5 only arises where, as here, the parties did agree to waive the precondition, and they agreed that the contract should become effective, irrespective of the fact that the licence extension had not been granted. And we say it's this situation and only this situation to which the intention or contemplation of the parties in October is relevant. And so the question the judge should have asked himself is this. As at the date the contract was entered into, what was the objective intention of the parties as to the effect of clause 4.5 in the event that the contractual precondition was waived and the contract became effective, notwithstanding that the extension had not been obtained? Now, I accept the parties almost certainly never, in fact, applied their minds to this scenario. So one is, of course, looking at the deemed intention, but then that's usually the case with questions of construction. But we submit that their objective intention at that date on that hypothesis would have been, well, all right, if the contract is nonetheless to come into force, it should simply apply in accordance with its terms. In other words, clause 0.5, like all the other clauses of the contract, to be given their ordinary and natural meaning with all the consequences that flow from that. The fact that obtaining the extension had previously been stipulated to be a condition precedent is now irrelevant because the parties have agreed to waive it. So in our submission, there is absolutely no warrant on this hypothesis to regard the fact that it was once a condition precedent as playing any part in the formulation of their intention as to what clause 4.5 should apply to. And we say that's where the judge went wrong, because he nonetheless allowed the fact that there had been this condition precedent to drive his construction of the clause. And we say he was wrong to do so. So we say the answer is simple. The objective intention of the parties, in the event the condition precedent was waived, was that once the contract was afoot, the ordinary wording should be given effect in the ordinary way. And it therefore follows, because this is what clause 0.5 says, that Tower is responsible and therefore liable for the cost of delays falling within the ambit of clause 0.5, which we say in this case was the absence of security.
It was pretty silly of them to agree the extension or waive the condition precedent.
Tower.
Yes.
Well, it's not for me to say, my lord, but they clearly...
Well, I mean, on your analysis, that was a jolly silly thing to do.
Yes, but they chose to do so, no doubt for very good commercial reasons, because they were worried. Geoquip had said in correspondence, and I think this is recorded in the judgment, if you don't get this extension by the 31st of December, we're going to sail away. And that was the last thing Mr. Asher wanted, because he wanted to get this survey done. But I think, my lord, it's probably fruitless to speculate as to why he may or may not have decided to pay the deposit when he didn't have to, but he did, and it was agreed. And I think it's paragraph 108 of the judgment, for your lordship's note, where the judge records that it was accepted by the parties that the contract was nonetheless enforced by January 2020. Now, if I'm right as to the objective contemplation and intention of the parties, that does not involve giving the clause a different construction at different points of time. There is one and only one construction, namely that 4.5 applies according to its terms in all scenarios. That is all that is necessary. In scenarios 1 and 2, the clause doesn't come into play at all. So there's no need to ask whether the parties intended or contemplated that it would or wouldn't apply to delays in getting the extension. It is sufficient simply to apply the clause in accordance with its ordinary and natural meaning, also in scenario 3, because the significance of the condition precedent has completely fallen away because it's been waived. Nor, we say, does this lead to any uncommercial results. Nobody forced Tower to pay the deposit and agree to the contract coming into force, but they did so and must now accept the consequences. So that's what we say went wrong as a matter of analysis. Which brings me on to the judicial sleight of hand. And we say what the judge appears to have done, although it's slightly opaque, I have to accept, but what he seems to have done is to say in paragraph 106, the parties did not intend clause 0.5 to apply to delays in getting an extension. Therefore, they positively intended it not to apply to delays in getting the extension. Therefore, clause 0.5 can only apply to delays which are not in any way caused by a delay in getting the extension. In other words, the failure to provide security has to be the sole cause of the delay to the exclusion of any part played by the extension. And we say that's wrong for two reasons. First, obviously, the potential application of clause 4.5 to delays in obtaining the extension is nothing. Well, we say he was wrong in his approach to the construction of clause 4.5, and I've made my submissions on that, I don't repeat them. But even if you assume he was right to say that the parties didn't objectively intend 4.5 to apply, having reached this conclusion, we say he then elevated that into a positive intention to exclude things from the ambit of the clause. And that is the only basis on which he can go on to say in paragraph 109 that clause 4.5 can only apply to failure to provide security if that was the sole cause. He has effectively turned clause 4.5 into an exclusion clause. And of course it is trite law that if you have two causes of a loss, one of which is positively excluded, then the claimant can't recover. But that, we say, is to turn the clause on its head. It's not worded as an exclusion clause. And the fact that the parties may not have contemplated ever being in this situation, which I accept, is not the same as saying that they should be objectively deemed to have intended clause 4.5 not to apply if they did find themselves in that situation. And there's nothing in the wording of clause 0.5 to suggest that it's intended to act as an exclusion. And this is a point that I made repeatedly, both in opening and closing submissions. And I can just give you the page references. It's supplemental bundle page 16, supplemental bundle pages 106 to 7, But unfortunately, it's a submission which the judge completely failed to address. And of course, if I'm correct that the only objective intention which can properly be attributed to the parties is that if they were to find themselves in this situation of the contract being effective and the precondition having been waived, if I'm correct that the only objective intention is that the contract should apply in accordance with its terms, then of course it all resolves into a question of causation on which I've already addressed you. My Lord, the final issue as we saw it was whether a lack of security was a facility or service, whether a provision of security was a facility or service to be provided by Tower within the meaning of clause 4.5. That is disputed by my learned friend, so I do need to deal with that. But I think I can take that briefly.
The judge thought it was capable of being said.
Yes, as did Lord Justice Phillips. But we say, my learned friend's point, and I think possibly his only point on this, and for this we need to go back to the contracts bundle. At page 115 of the electronic numbering. What my learned friend says, as I understand it, is that when you look at the words we rely on in clause 4.5, materials, services and facilities to be provided by the company, you have to read that in the context of the remainder of clause 4, and specifically he says that it must therefore have the same meaning as the comparable words in clause 4.1, which are all to do with matters to be provided by Geoquip, and therefore it only contemplates facilities being something physical, tangible. Now we say there's absolutely no reason why facilities should be limited in this way to the similar sorts of things as Geoquip would provide. Indeed, we say it's nonsensical to equate the facilities to be provided by Geoquip with the facilities to be provided by Tower. It's like comparing apples with pears because they were contributing wholly different things to this project. Geoquip was providing mainly physical assets, the vessel, the crew, an onboard laboratory. It was providing services in the sense of procuring onshore lab testing, drilling. But Tower didn't have to do anything like that. Tower's role in this contract was basically to facilitate the performance of the survey by ensuring that all necessary licenses and permits were in place and that security vessels were provided so that the vessel didn't get attacked by pirates. So we say that the proper approach is to read the word facilities in the context of the parties' respective contractual obligations. In other words, it applies to such materials, services and facilities as each party was respectively obliged to provide under the contract. And I don't place much weight on this, but it's a point from which, if I'm right, you may derive comfort, which is that the last sentence of clause 4.5 on which we rely is a specific addition to the logic terms. It was not part of the standard wording. So we say, just looking at the ordinary and natural meaning of the word facility, the provision of security to enable safe access to the site and during the work and back again is clearly a facility covered by this clause. But in any event, the debate over whether provision of security was a facility, we say, is somewhat arid in circumstances where clause 4.5 also covers the provision of services. And we say quite obviously the provision or arrangement of services, of security is a service which enables the survey to be carried out in safety. That was a service that Tower was obliged to provide under Clause 34 and Clause 10.2. Obviously, it wasn't going to be Mr. Asher himself manning the bow with an AK-40. So it plainly had to be obtained, procured from a third party. But as between Tower and Geoquip, this was a service which Tower was to provide. And we say there can be no real answer to that point. So clearly, provision of security is covered by Clause 4.5. So, my Lord, unless I can assist you further, those are my submissions. In summary, 4.5 applies to delays caused by failure to provide security. On its proper construction, the clause does not exclude delay caused by a failure to obtain the extension. The sole cause of the delay was in fact the failure to provide security, but even if that's wrong, it's sufficient that the delay was caused concurrently by a failure to provide security in conjunction with the lack of extension.
Thank you very much, Mr. Phillips.
My Lord, my Ladies, 3 observations at the outset, if I may. And these are all to do with, I think, the difficulty and why this may be a complex case, as my Lord the Master of the Rolls suggested. The first is that the contract with which the court is concerned is not a model of clarity. It has been constructed on the basis, as I think my Lord Justice Sheeman once described it in the Court of Appeal in Kuwait Airways, on the kebab principle of draftsmanship, in that clauses have been garnered from various places and skewered together without necessarily thought being given as to how they fit. But the court is nonetheless concerned with this.
Keeps you in business, Mr. Phillips.
Sorry, my Lord?
Keeps you in business.
I think one of my children would say, right back at your lordship. Anyway, your lordship, my ladies, have the point. The second problem is that it is common ground between the parties today, and indeed was common ground at trial, that notwithstanding the contingent nature of the contract as spoken to in clause 10.2 of the technical and commercial proposal, whatever contingency existed was lifted as it was dealt with at trial, not later than the beginning of January of 2021. Forgive me, January 2020. And it was my learned friend's case, and it was common ground that whatever condition upon which the contract was contingent had been lifted, and I'm prepared to say today that that was no doubt on the 24th of December when the money was paid. 29th. I'm not going to get any dates right today. The third problem, and I mean no disrespect because I quite understand why my learned friend has to do this, is that the case that is addressed to this court is not, putting it kindly, on all fours with the case that was addressed to the learned deputy judge. And I just want, if I may, I'll come back to the examples that we gave in writing, where I had understood that it was common ground as a matter of causation between the parties at trial, that any absence of security was essentially caused by the absence of a presidential decree. But I just wanted to give one further example, and I'm not seeking unnecessarily to tweak tails, but if my lord and my ladies were to look at a question posed by the judge in relation to, I think, clause 10.2 in the submissions addressed by my learned friend in closing, which is in the supplemental bundle behind tab 3. It's the transcript for day 4. And if one goes to page 105 of the bundle, internal pagination 59 to 60, the learned deputy judge asked my friend what her case was as to the phrase license extension required for the site survey, lines 24 to 25, And he asked essentially whether that refers to whatever the final document, which is of legal effect, is. So the presidential decree, essentially. And the answer given by my learned friend at that stage was yes.
Oh, yeah, I see. You say the phrase license extension required for the site survey. That refers to whatever the final document is. So the presidential decree, yes.
Whereas, and I make no particular point about this,
Yes.
I think what is now being said, albeit that this is not addressed in writing or in the grounds of appeal, is that as a matter of fact, that was an irrelevance. Because there was an earlier decision on behalf of the Prime Minister, I'll come back to this, or the Minister of Mines, essentially to approve this licence, and that was what mattered. Whereas what mattered, at least as I had understood the case that as it was put at trial, was that what mattered was the formal document. And in fact, my learned friend was absolutely right about that, and it would remain right about it were that still the position today. But when we get to causation, none of that matters, of course, because the fact of the matter, and I shall come on to deal with the evidence of this, is that the BIR would not provide security until authorised to do so by SNH. And SNH would not give that authority until they had seen a presidential decree, or as matters emerged following the involvement of the British High Commissioner, some form of direct instruction was given by the presidency. Now, those were three observations which, having listened to my learned friend's submissions, I wanted to address at the outset. But I wanted to, if I may, subject to any direction from the court, perhaps encapsulate in a single submission the error which in our respectful submission underpins the case so skillfully presented by my learned friend on behalf of the appellant this morning. And that submission is this: that what the appellant, Geoquip, seeks to do in order to secure to itself this, as we describe it, windfall of $1.8 million at issue on this appeal, is to elevate to a cause of the delay in the vessel's operations what, both as a matter of contract and on the proper analysis of the facts which gave rise to that delay, is something which is itself a symptom of the true cause, namely the absence of a presidential decree extending Tower's licence. A symptom which the parties could never have intended on the basis of the bargain struck, as the judge correctly held, to give rise to the entitlement that is asserted to my lord and my ladies.
Now, why is the court concerned with the causes that may have given rise to an NSH, is it, being awkward, if you like, and saying it required to see the decree? I mean, if 4.5 means what the judge and Ms. Dyers says it means, it encompasses a failure to provide security. If you're right, everybody seems to agree now that the precondition was waived, so there was no precondition requiring a decree anymore, requiring to bring the contract into effect. Why doesn't 5.4 take effect according to its terms? And if facilities includes BIH not being provided, that was your obligation and bad luck. You were stupid to waive the precondition.
The answer to that, my lord, is because, and I'll come to the clause in a moment, there are two distinct requirements in clause 4.5. Perhaps I'll go with it now. If my lord and my ladies are to turn up clause 4.5, which we've been looking at in the...
I think it's best to look at it in the contract.
Finally, in the contracts bundle, albeit, of course, that where we're looking at is at 115. 5, as I understand it, of the electronic bundle is in fact a document that was created for the purpose.
Yeah, but it's common ground, that's correct.
It is common ground.
Yeah, good.
Now, the words that my learned friend relies upon are the words contained within the final sentence.
Mm-hmm.
Now, if such, and that must mean materials, services and facilities, are delivered late and cause delay in the performance and downtime of Geoquip's equipment, then there becomes an entitlement to standby time. So whether as a matter of causation, as a matter of law, or as a matter of the contract that was agreed between the parties, it's not enough, in my respectful submission, for there merely to be a late delivery. The late delivery must cause delay in the performance and downtime of the contractor's equipment. And that cannot be the case, in my respectful submission, where the delay is in fact caused by the absence of the presidential decree. And I come back to the symptom point, that the absence of security is not anything other than a symptom of the absence of the presidential decree, and whether as a matter of strict causation in law or as a matter of the construction of these words in this contract, the absence of security does not loom large or have any operative effect in the causation landscape. It is entirely...
I don't really understand that at the moment, actually. I mean, I don't see why we're concerned. I mean, quite plainly, on the analysis of the two requirements, in other words, there's late delivery of security, yes there was. The absence of security was one cause of delay in the performance of the contract. The fact that it was caused indirectly by something else, why does that matter? That's not normally the process the court follows, to say that, well, it was actually, it's true that the security wasn't provided, it's true you were obliged to provide it, but actually it couldn't be provided because something else wasn't provided.
It is because, as a matter of the construction of the clause, the absence of security is causatively irrelevant to the alleged performance and downtime, delay in the performance and downtime of the contractor's equipment.
Is it?
That is the submission, my lord.
I mean, she says, I mean, I'm sorry to make it sound rude, but Miss Dyer says that it was a precise cause, because actually could have gone out and done the work if you'd had security, because the presidential decree wasn't needed. See all the evidence she took us to.
Yes, which I don't accept, but let us assume that she were right for those purposes.
Yeah, let's assume it's right, because obviously you're going to make submissions on why it's wrong. But
what
assuming
is
it's right? Surely that is a cause of the delay in the performance.
But in my respectful submission, not. It wouldn't be regarded as an effective or operative cause if this were purely being approached as a matter of law, and where the word cause is used in that final sentence of clause 4.5, it should have the same effect that it does in the general law, and it is not an operative cause of the delay because it's itself dependent upon the absence of security. It is not to be regarded as a cause for the purposes of that clause.
Sorry, what is itself dependent on the absence of security? You mean
sorry, I had it the wrong way around.
Yeah.
The absence of security is itself dependent upon the missing promulgation of the presidential decree.
Which isn't really, is it? I mean, just because they gave as a reason, they might have given as a reason that President Biden was got less votes in the polls in America. Doesn't matter what reason somebody else gives. You have an unequivocal obligation to provide security, and the only question for causation purposes is: did you, and did you fail, and did that cause the work not to go ahead? But everybody seemed, the judge anyway, thought that was open and shut.
what caused the work not to go ahead, in my respectful submission, and we'll come to the...
You're now looking at operative cause. You're saying what is the fundamental clause, but you're not just applying a but-for test.
No, and indeed in Arch we are told that the but-for test, well, in several cases before, is unsatisfactory for
Well, this is not an insurance contract.
That I accept, my lord. I haven't cited any authority.
No, I know. You haven't cited any authority at all, but what I don't understand is how you can, without citing authority, get over the judge's holding that there were several operative causes which operated in parallel.
Well, my lord, the answer to that, and I've addressed this submission, is because as a matter of construction of Clause 4.5 and as a matter of general law, the absence of security as relied upon by my learned friend is not to be regarded as a cause of the delay, the alleged delay in the performance and downtime of Geoquip's equipment. It is causatively irrelevant for those purposes.
Why?
Because
I mean, if she's right, this is all on the if she's right.
It is
That
because...
as to that the judge heard evidence that by this time the question of the decree was from your client. Mr. Asher said the question of the decree wasn't what we were worried about. We were worried about BIH. BIH were being awkward, and that's why we couldn't get out there. We could have got out there. BIH could have, if we'd had BIH, could have got out there.
I think your lordship's question is, why is it causatively irrelevant? And that
Yes,
is...
I mean, I just don't understand what BIH's reasoning in not providing the security has got to do with the fact that you failed to provide the security, and that if you had provided the security, you would have actually allowed the vessel to do the work.
Well, I mean, that is the assumption, my lord, but of course the vessel can't go to the project site and begin the survey work until such time as the licence is extended. And the licence is not extended until such time as the President...
Point.
I'm sorry, my lord?
That's a different point. That assumes that she's wrong in saying that the vessel could have gone to the site and done the work before.
But that point, in my respectful submission, feeds in to the question of what is the cause of the alleged delay, which is in itself a question which is linked with what is the operative cause as a matter of law. What is it that looms large in the causation landscape, which in fact caused the delay in the survey here? And there is only one thing.
Where is the words operative cause in your respondent's notice? Where is it ever mentioned in this case before now? Because when I looked at this case, I thought this is a case about operative cause. We're going to have lots of authorities on operative cause. It's a concept well known to the law. But that's not what's said.
The answer to your lord, the specific answer to your lordship's question is that it's a 2B of the respondent's notice on page 49 behind tab 5. In the result, the judge should have found that the only operative or effective cause of any delay was the absence of a presidential decree confirming the licence extension.
Yeah,
Now
the
that's
only cause.
The only cause.
Yeah.
And that is the case
The
on the
answer to
respondent's
that is
notice.
not on the evidence correct.
Well, may I in due course come back to...
I mean, what I'm putting to you is all on the premise that what she said about the evidence is correct and made good. I fully understand your point that I put it to her that your case was that the only cause, I forgot that I read out operative, the only real cause was the lack of a decree. But that doesn't seem to have been the evidence.
My lord, may I... part of the problem, I make no particular complaint in this regard, is this was really an appeal about clause 4.5 and its meaning. It wasn't if I may say so, an
Factual
appeal where we
appeal.
were going to go back into the facts.
I know. I mean, that's why I started by saying it's such a funny case.
And that may be a fourth reason to add to my the initial observations that I, with respect to.
But it makes it difficult for us if she is right about what she said.
Well, where my learned friend dealt with facts in her skeleton argument, which was of course before my Lord Justice Phillips for the purposes of the application for permission to appeal, we addressed those facts by reference to the evidence, and that is as it were, the evidence that I came to this appeal prepared to deal with, and I'll come back to that in a moment. There has been a great deal further by way of citation of evidence to my Lord and my Ladies this morning. And the difficulty which that creates is that I'm having to try and field that on the hoof.
Well, there's only one, I mean, we saw a lot, but the only thing that made a particular impression on me was your client saying, seemingly repeatedly, that what bothered him was not having BIR, and perhaps the rider to that is it was in the bag, the decree, and we could have gone ahead without the piece of paper if BIR had been there. That's the bit of evidence that matters.
Can I just then, I'm going to take this out of order, for which apologies, unless I'm directed not to. But can I just look at the evidence that we set out in writing, which is relevant to this question?
Yeah.
Or the references to the evidence.
Where's that?
Well, Your Lordship will find it in my skeleton. I think it's paragraph 19. But the overarching point which is being made in the evidence, in my respectful submission, is that whilst the BIR is the practical problem, the reason the BIR won't move is because it hasn't got instructions to do so, because there is no presidential decree that has been promulgated. And my learned friend, in seeking to support the submission that security was entirely independent of a presidential decree, addressed in her skeleton argument a number of matters at paragraph 12.7. I deal with those not in paragraph 19, forgive me for the wrong reference, but in paragraph 12.2.
Because there isn't 19.
No, well, that's
Okay.
it's always a good thing, a shorter skeleton.
We got 12.2. They were very short skeletons. Commendably so.
Well, I'm sure we're both grateful for that. Now, my lord, the first point which my learned friend reiterated this morning is that when the vessel arrived off of Cameroon, she was provided with security. Now, in fact, and I don't think he was challenged on this, Tower's evidence was that the vessel entered Cameroon without security from the Bataillon Intervention Rapide.
Fantastic pronunciation.
I'm very grateful, my lord. Now, my lord, I'd better just show your lordship and my ladies that evidence, if I may.
But I don't think you need to, because the question of whether security was provided for other purposes in other ways is quite irrelevant to this point.
That was the second point that I was going to make.
Right. The only thing that matters is whether security was provided to allow the job to be done, and it wasn't. Right? And it was provided for all sorts of other things, but it was not provided to allow this job to be done. And you say that it was not provided because of the absence of a presidential decree, and the only thing that caused the failure to do the job was the absence of the presidential decree.
Yes.
Miss Dyer says, anyway, at first sight, with some foundation, that actually that is nothing to the point because it could have gone ahead without it.
Yes. Well, I'm not sure that that's how the case was presented to the Learned Deputy
No,
Judge below,
it
and that
wasn't.
may be
Is
why
that-
there are no findings in this regard.
Yes, and is that a point you can make?
I think on the basis of my learned friend's grounds of appeal, it is a point that I can make.
Should we look at them?
Yes, of course, my lord.
Because I find them a bit tricky. not tricky enough. Not you know what I mean. Kind of difficult.
Can I am afraid I am going to have to take this point. But if these were matters about which she had wanted findings, firstly, they should have been addressed to the judge in the terms that they're now addressed to this court. And secondly, if the judge hadn't dealt with them, which is essentially the position that we now find ourselves in as a result of the judgment, then perhaps further reasons should have been asked for. And third...
That's very unorthodox, but well, the first point is, if I may say so, interesting, and it's the first time, sort of 3/4 way through an appeal that I remember, that somebody has said, well, the point's not open, because although there was evidence before the judge was not asked to make findings on those points. I mean, you may well be right, Mr. Phillips, don't be put off, but you perhaps caught a little bit by surprise, are you? Is it marked in her skeleton? It is, isn't it, that she's going to look at these bits of evidence?
The ones that I've addressed, yes.
No, the ones that
no.
She referred to.
No, they're all new today, with one exception, which was a passage I was going to come back to.
Okay. All right. Anyway, should we just look at at her grounds?
The grounds of appeal.
Just to see whether they really do mark this or not.
And we are, Your Lordship, my ladies are concerned only with ground 1.
Sorry, what's the page in the election?
Oh, I'm so sorry. Behind tab 1 of the core bundle, the core bundle, the appeal core
tabs
bundle.
don't help me, but page.
And at page 12, there are the grounds of appeal as set out. Now, we'll see this in a moment, but paragraph 2 is headed specifically, so one assumes that it is unpacking paragraph 1. And paragraph 1, on which permission was of course granted, is that there was an error of law in relation to a holding that there was no contractual right to standby charges under clause 45 and 34. Now, in fact, it doesn't matter because I accept that there was an obligation in the TCP to provide security, but clause 34 isn't relevant for these purposes. So that, in my respectful submission, is a ground which is asserting a pure error of law. It doesn't involve any fact at all.
Yeah.
And then we have that unpacked specifically. Paragraph 2.1 is solely a point of construction. So that is, again, solely a point of law. And then we come to what I understand my learned friend to rely upon, which is where the concluding words of paragraph 2.2, where the failure of the first defendant to provide security was an independent concurrent cause of the delay. Now, I take no point on whether that's designed to mean cause as a matter of law or cause within clause 4.5, but if that was designed to open up, as it were, a wide factual inquiry, which is not then dealt with in the skeleton argument, which was before the court for the purposes of granting permission to appeal, that is not, in my respectful submission, a way in which I can be bounced to now having to deal with these points on the hoof. And so, if my learned friend wanted significantly to unpack the evidence for the purposes of this appeal, she would have needed to go on and say, and deal with in her skeleton argument, here is the evidence which demonstrates that the judge's conclusions, as a matter of law, given that evidence, were wrong. And I mean, these things happen, but I do rather feel today as though there has been a certain amount of what one might describe as mission creep. And your lordship and my ladies have been shown a great deal of evidence, which is just not foreshadowed anywhere. And where essentially a finding of fact is now, or findings of fact are now as it were, sought to be supported or indeed
do you
changed.
say, can I be clear about this? You say that this ground, which is really the main foundation of the appeal, cannot be advanced without an amendment to the appellant's notice.
Yes. And, if I may say so, adequate notice of what the case that is going to be advanced by reference to the facts is, given the evidence that was given at trial.
I mean, you did say a minute ago that you were able to answer the point on the hoof.
Well,
And I'm not saying you need to be, but I'm interested to know what the answer in one or two sentences is on the hoof. Simply because, well, it's interesting, isn't it?
fairly read, the evidence of Mr. Asher, and I'll show your Lordship and my ladies in a moment a passage that's already been referred to, is that behind the problem with the BIR was the problem with the promulgation of the presidential decree. In other words, that security could not be provided, and certainly would not be provided, without that the presidential decree was first promulgated.
And that, you say, presumably, is why the judge effectively so found.
Yes.
That was the dominant cause.
That given my, I say it's the only cause on the basis of my respondent's notice.
The only
It's open to me on the appeal, I think, to say it's the dominant cause.
Yeah.
But I accept that on the respondent's notice, which I think may, actually that second paragraph may be unnecessary, because that's dealing with causation as a matter of law, and the court is actually concerned with causation for the purposes of the construction of the second limb of clause 4.5. But yes, the dominant, effective, proximate cause. And the passages in the evidence that we have, well, that I addressed in the skeleton argument are designed to deal with the evidence that we anticipated was going to be put forward in that regard.
I think we should just ask Miss Stiers, because this appeal is supposed to have 22 minutes left to run, whether she intends to be applying for permission to amend her respondent's notice. Appellant's notice.
If amendment is thought to be necessary, then yes, we do. But we do submit, given the terms of the respondent's notice, that the sole cause of the delay was the absence of the decree. We say this is a matter that I'm entitled to address in that context, if nothing else. And if I'm right on the point of construction, of course, it's not necessary for me to go so far as to say that absence of security was the sole cause. It's sufficient that it was just an equal or concurrent cause.
Yes, but you do have to get over paragraph 10, whatever it is, 109.
Well, the only reason I have to get over, I'm sorry, I'm trespassing on my learned friend's submissions, but the only reason I have to get over 109 is because the judge has effectively said that any delay attributable to the failure to obtain the license extension is excluded from 4.5.
So while you're on your feet, what do you say we should do? Mr. Phillips takes a point against you that the main argument you've raised is not open to you, which at least seems to me to be an arguable question. You say if we, I don't know whether you say if we agree, but we're not going to tell you whether we agree or not anyway. And so I'm taking it that you wish to amend your grounds of appeal, which you cannot do before 1 o'clock. What do you suggest we do about the hearing of this appeal? Because very shortly, I think we're going to rise to decide what we are going to do.
Yes. May I take instructions?
Of course. And Mr. Phillips might like to take some instruction. Well, I don't know whether you need to.
May I turn my back for a moment?
Yes, you may.
Okay. Forgive me.
Well, I'll hear Mr. Dyers first. Yeah, what do you say we should?
My lord, I don't know how the court is placed.
You don't know?
How the court is placed this afternoon, but we are certainly prepared to draft an amendment to the appellant's notice over the short adjournment.
Well, I don't know how the other members of the court are placed this afternoon,
precisely.
but I know that I have. I'm just looking at my dates and things in my diary. I have 2 meetings this afternoon. But you would prefer to go on this afternoon, is what you're saying?
Well, my lord, I'm in some personal difficulty if we do not conclude the appeal today.
No, quite. And Mr. Phillips, what do you say we should do? So we should let you go away, put together an application to amend, come back and finish the argument this afternoon, is what you say?
I'm entirely in the court's hands, but that would be our...
Yeah, and you, Mr. Phillips?
Firstly, at least at the moment, I do not consent and will likely oppose any application to amend the grounds of the
I'm sure you will. And indeed, we won't be dealing with it on the hoof, but we will probably, having heard the argument this morning without objection from you, you held your seat, if I may say so, in an extremely stoic manner. But
I wasn't intending to waive anything by doing so.
no, of course you weren't, and you're perfectly entitled to do what you say.
But secondly, if an application were made and if it were granted, then I want time to be able to deal with what the factual appeal is. Which means that although, of course, I have read the passages to which I've referred in my skeleton and those referred to in my learned, we're going to have to go back through the trial evidence in circumstances where there's no real...
Which you say can't be done fairly today?
I can't do it fairly today. I simply can't.
That's a considered submission. I'm going to let you think about that, bearing in mind what Ms. Dyers has said about her personal position, which I think may mean she can't.
Which I well
adjourn
understand.
the case very long.
Certainly for very long.
Okay. Well, could you talk to each other and see whether there's any possibility of, if from your point of view, the case could be adjourned for a short period. If not, let us know. We will meanwhile rise for 5 minutes just to decide what we think we might do.
Of course. I'm grateful.
Thank you very much.
Let's just talk about I am sitting next week. I'm going home to Switzerland tomorrow. I'm sitting next week. The following week I have the case management conferences in the aeroplane cases, and then I have a conference in Dublin, and then I have a day of meetings in Paris. So when do you go to your own time? Well, I'm very happy for you to get this finished.
Let me go and
You need to get this finished and out of the way, and I want you to get that done. But judicial, the appointment next week is in the diary, and you will know that as far as the MOJ and the court is concerned, judicial appointments take precedence. We could put quite a lot in writing and be guillotined, both of us.
yes, I'm allowed.
That's to put stuff in writing. Oh, what I meant is we put it in writing next week, and then find a 2-hour slot before the 20th. So, for example, right, so AirCap is 13th, 14th. I'm in Dublin all day on the 15th. The 16th is
What
the
days are you free
Thursday.
between now and the 20th?
So I haven't got my diary. I think the 17th. I think Friday the 17th I can do that before I go back to Thursday. But are you available then, if they can fit in? I'll come down.
Yes. I mean, I'll have to take instructions.
Of course.
The alternative is that we abandon any
Well, you have to take instructions as to whether that's your position.
But I mean, if it were truncated,
You would say you'd accept it's a concurrent clause, and you'd say it's purely a matter of the construction of clause 4.5.
yes, excluding.
Well,
I mean, I accept the equal clauses. Well, I mean, I just rely on the equal clauses.
but the problem with that is that I will immediately turn around and say respondent's notice,
Yes.
on which you'll want to rely upon all the passages that you referred to this
Exactly.
morning.
Which I'm entitled to do.
Well, we can have that fight. Anyway, why don't you take some instructions on that, and then we could do it this afternoon, maybe.
Yeah.
Don't worry about you. No, not at all. No, but the concurrent clause one will lose because it's not excluded. What, would their response notice? Would they have raised all the factual material that they want to put for the court? That is our case, about which we're probably wrong. And it's always been the problem on the scores, which you've always been worried about. Yeah, I took it before I left, I'm afraid. Why don't you dive out to the chemist? Rebecca, I can deal with it. Go and get something. Mm. And you're. Mm-hmm. I understand. Right.
I think we can proceed on that basis with the rules that can hear us.
Yes, but they may be able to put us in for time this afternoon.
I can hand out our speaking note.
I'd rather you didn't.
Yeah, okay. Let me just notice what I said. That's fine.
That's a matter for them.
Yeah.
Okay.
So, if we proceed on that basis. How much longer do you think you have to go on that basis? I'm just wondering the time.
Well, I'm, haven't done anything yet.
No.
So I've got
that's
8
all right.
pages. So at least 40 minutes.
Right, so we've thought about this. I mean, on one analysis, of course, the respondent's notice reopens the question of causation, in fact, because it challenges the 3 causes finding by the judge. On another analysis, the way you have argued your appeal, Dias, has been unheralded, shall we say, as a matter of fact, and that is the way you argued your appeal, as opposed to respond to the respondent's notice. At one point I was going to say, well, let's deal with the respondent's notice when Mr. Phillips gets to his feet. Our view, if this is possible, is that it would be better to deal with this in proper time, so that nobody feels they are unduly rushed or surprised, and that we would therefore prefer, if this is possible, to adjourn now, for you to promulgate an amended notice of appeal, if that's what you want to do. We would then deal with that in writing as to whether you should be permitted. Well, we might or might not. We might just let you promulgate it, depending on timing. And we could sit on this for half a day next Tuesday morning. How does that accord with Diaries?
I could certainly make myself available, my lord.
The difficulty, my lord,
We
is,
could do it remotely.
please forgive me, it's not a council commitment. I have a judicial commitment next week. And
All week.
Monday to Friday, and the rules, as your lordship and my ladies may remember,
As a recorder.
yeah, is that they take precedence, and there's nothing I can do about it.
My lord, I don't know if this might provide some way of cutting the Gordian knot. I have taken instructions and discussed with my learned friend, and we would be content not to pursue as part of the appeal any argument that lack of security was the sole cause of the delay. We would pursue our points of construction and argue that on that basis the judge's finding in paragraph 109 that lack of security was an equal cause of the delay is sufficient for our purposes. I would nonetheless argue, as your Lordship has already pointed out, the respondent's notice does reopen the whole question of causation, and in response to that, I would rely on the evidence that I've already put before your Lordship.
But that leaves Mr. Phillips in exactly the same problem as he was before you were trying to find a solution, because he still hasn't had an opportunity of going through the transcripts and see if the totality of the evidence as he and his team approach it.
We would not
provides
object.
any answer.
I'm so sorry, my lady. We would not object to his client, him being given an opportunity to put in written submissions on the transcript references to which I have referred, if the oral argument can be concluded today. But that very much depends on your Lordship's other commitments.
And is it impossible for us simply to adjourn and refix the appeal urgently, but not next week? Is that impossible?
The following week. There become possibilities. As my Lord may be aware, the case management conference in the Russian aircraft cases are on the 13th and 14th. They involve a not inconsiderable amount of work, but that's irrelevant. I then have other commitments, professional commitments overseas, also in connection with Russian aeroplanes, in one case, not in another, on the Wednesday and the Thursday, but I could do the 17th.
Right, well, let's not try and do diaries.
I'm so sorry, my Lord.
That is utterly impossible. The 17th is impossible for me, looking at my diary anyway. But what I would suggest is it fairly possible, in your estimation, Mr. Phillips, to deal with the rest of the argument that you would like to address today, and for you to put in written submissions about the evidence, insofar as you are surprised by what Ms. Dyer said this morning?
Subject to start sharp tugging from behind, I'm going to say yes, because I think that would assist the court, and also I think this matter needs to be concluded.
It would assist the court, and the matter would probably be better concluded. I have a rather bad feeling that if we adjourn it from today, we're not going to find a date when everybody can be here again. And so what I'm going to say is then, subject to my ladies happy, we'll rise now, we'll resume at 2 o'clock on that basis. If Ms. Dyers could put together an amended notice of appeal for which she'd like to apply over the adjournment, that would be, you may say you don't need to, it's up to you, but if you want to, I think it's not unreasonable to ask you to do so over the adjournment, and let Mr. Phillips see it, and let us see it. Bear in mind that it'll be electronically that I shall need to see it. Okay, 2 o'clock.